Welcome to this explainer. Today, we're completely demystifying the complex and honestly fascinating world of the Anglo American legal system. We're going to see exactly how an 800-year-old legal philosophy doesn't just sit around in dusty textbooks, but literally dictates the terms of highly modern, multi-million-dollar construction contracts today. If you've ever wondered why international business deals sometimes hit a massive wall of legal culture shock, well, you are definitely in the right place. Let's get into it.
Just to keep us perfectly on track, here's our roadmap. We're going to quickly define what Anglo-American actually means, compare common and civil law, check out the system of precedent, look at the role of legislation, and finally, dive into the very real modern friction of good faith contracting.
All right, Section 1. What does bedeutet Anglo-Amerikanisch? Let's define the region.
So, this table beautifully illustrates the vast geographic footprint of what we call Anglo-America, which is basically the English-speaking Americas, totally distinct from Latin America. We're talking North American powerhouses like the USA and Canada, though we leave out French-speaking Quebec, but it also stretches way down through Central America to Belize, across the Caribbean to places like the Bahamas and Jamaica, all the way down to South America, hitting Guyana and the Falkland Islands. What connects all these incredibly diverse regions? A shared legal legacy. And honestly, that legacy extends even further globally to former English colonies like Australia, New Zealand, and India.
Moving right along to Section 2, common law versus civil law. This is the philosophical engine driving everything.
Now, the contrast between these two legal worlds is pretty wild. Over in continental Europe, places like France and Germany, they use a civil law system. That means legal scholars write out these massive, abstract, comprehensive codes, and judges just take a specific case and categorize it under those written rules. It's a process known as subsumption. But the Anglo-American common law system, it's fundamentally different. It is unwritten law. It relies heavily on analogy. Judges literally compare the specific, messy, real-world facts of the case right in front of them directly to the facts of past judgments. And I think this quote absolutely hits the nail on the head regarding the core identity of common law. Back in 1881, the famous American jurist Oliver Wendell Holmes said, "The life of the law has not been logic. It has been experience." I love that. The system isn't some cold, rigid, mathematical formula locked in a codebook. It's a living, breathing organism built entirely upon centuries of practical, human experience, figured out dispute by dispute.
So how does that experience actually become binding? Section 3, the system of precedent. The absolute crucial piece of the puzzle here is the doctrine of stare decisis. It's Latin for to stand by things decided, or in everyday terms, binding precedent. Because there isn't some giant code book for every possible scenario. Courts in the Anglo-American system don't just interpret the law, they literally build it, case by case. Once a higher court makes a decision, boom, that decision becomes the law for similar future cases. So let's look at how this actually flows through the court hierarchy, using traditional England as our model. Basically, binding decisions trickle down from the absolute top. A decision made by the House of Lords, which historically acted as the Supreme Court here, is binding on the Court of Appeal. Then the Court of Appeal binds the High Court of Justice, which in turn binds all the lower courts. It is a very strict chain of command based entirely on legal experience. But, interpreting those historical cases requires some serious precision. Looking at this detailed index from Dr. Dieter Blumenwitz's authoritative text, you can see that understanding precedent means a lawyer really has to dissect a judge's ruling. You have to clearly distinguish between two things, the ratio decidendi, which is the actual legally binding reason for the judgment, and the obiter dictum. Obiter dictum just refers to incidental remarks or side opinions the judge threw in by the way. They're interesting, sure, but completely non-binding. Finding that golden ratio decidendi is literally the heart of common law practice. All right, let's pivot a bit. Section 4, the role of legislation, covering statutes and equity. So, while unwritten case law is the absolute foundation, parliaments and legislatures do still enact written codified rules, which we call statute law. Think of this as a vital counterbalance. If the public or the government really doesn't like the direction a judge-made common law is heading, Parliament can just step in, pass a statute, and override it completely. And then there's this other fascinating layer called equity. Sometimes applying strict common law precedent actually causes unintentional, severe hardship. The system is smart enough to realize this happens, so it developed equity, which is a concept very similar to fairness. Equity essentially steps in to fill the gaps and provide relief when the strict rules are just way too harsh. It really proves how incredibly flexible this whole system can be. Obviously, all of this builds a highly complex framework. Mastering how common law, written statutes, and fairness-based equity all intertwine, that requires intense study. That's exactly why authoritative academic works exist, like Dr. Blumenwitz's text right here. These act as vital maps to guide legal minds through this crazy maze of history and modern rules.
Which brings us to our final stop, Section 5, Good Faith in Contracting, and the huge friction it causes today.
Here is the massive, surprising friction point we've been building towards. Historically, English common law prioritized strict contractual certainty above almost everything else. They wanted to promote trade, and they believed the best way to do that was to ensure that if a rule was written down in a contract, it was followed to the absolute letter, no exceptions. Because of that, the system effectively abandoned the broad philosophical concept of good faith that you see in a lot of other places. And here is the modern battlefield. On one side, we have the civil law approach. German and French codes explicitly demand that contracts be performed in good faith. I mean, Section 242 of the German Civil Code literally creates positive duties to cooperate. But on the other side, traditional English common law avoids those sweeping principles. English courts prefer to tackle unfairness piece by piece. They'd much rather come up with ad hoc solutions to very specific problems than commit to a broad, vague duty to just be nice. In fact, traditional English judges have historically viewed a broad duty to act in good faith with, frankly, extreme hostility. The sentiment is summed up perfectly by Lord Ackner in the landmark case of Walford v. Miles. He flat out stated that a duty to negotiate in good faith is inherently repugnant to the adversarial position of the parties involved. The traditional view is basically, hey, you're in business to make money for yourself, not to look out for the other guy. But here is exactly where the rubber meets the road. The modern construction industry desperately wants collaboration to reduce costly disputes. This has led to the creation of modern partnering contracts, things like the PPC 2000 or the NECX 12. These contracts explicitly try to force parties to act in good faith to build a no-blame culture. And this creates a huge tension. We literally have businesses voluntarily writing these soft obligations of trust into their contracts and then handing them over to English courts that historically despise those exact concepts. So how on earth do we bridge this gap? Well, Australian judge Paul Finn offered this brilliant definition that shows how common law can actually integrate this concept without losing its core identity. He notes that good faith occupies a sort of middle ground. It allows you to act in your own self-interest, sure, but it positively requires you to at least have regard to the legitimate interests of your partner. It's a much more structured, practical way to actually enforce collaboration. Which leaves us with this final, provocative thought to take away from this explainer. As global businesses continue to demand more trust and collaboration in these massive, multi-million-dollar projects, will the ancient, experience-driven English legal system finally adapt and concretize this duty of good faith? Or will these modern partnerships remain nothing more than an unenforceable wish in the eyes of the law? It is quite literally a multi-billion-dollar question, and watching how this 800-year-old system evolves next is going to be absolutely fascinating.